Hi everyone, I'm JD Hoovener, your host of The Bold Today Show, where you, the inventor, entrepreneur, and business owner, get your daily dose of inspiration to make the world a better place. We're here talking about Money Week, and I want to remind you real briefly, for those that you might have missed it, yesterday we talked about patent enforceability. When you're building a business and you want to protect your invention, the number one way to make money is to make sure no one else gets in your industry, and that's through enforcement. What I forgot to mention was that there are lots of different venues where you can bring your lawsuit. You can take it to federal court, take it to the Patent Trial and Appeal Board, or you can take it to the International Trade Commission, the ITC. Those are all different venues that can help you enforce your patent rights and get you different results. So today we're talking about different ways to bring in money if you're the inventor or even a business and you want to think about, well, let's not grow a business out of this. We want to be able to license our rights to get a royalty. So making money through royalties. How does it happen? Well, the number one way is by contracting with at least one other party and giving up part of what you own. Don't forget, as a patent holder, you have 4 distinguished rights. You have the right to prevent anyone else in your jurisdiction, let's just say the United States, from making, using, selling, or importing into the US. And so you can license any one of those rights, and in an exclusive or a non-exclusive manner. It's important to work with an attorney and a patent licensed attorney in order to make sure you structure the deal very favorably to you. You want to make sure you negotiate important terms such as the term, right? How long is the license good for? The grant, what is it? What of those 4 rights are you giving up? And in what manner? As I said, whether they're the exclusive, whether they're the only manufacturer that can make it, or if they're one of 100 that can make the same product. Of course, the grant clause, which is your ability to give up those rights, and what royalty you receive from that. Really key terms to think about in that contract. There's a lot more to think about when it comes to licensing law, and that is especially regarding the performance clause. Under the exclusive contracts under license agreements, there's a lot of cases that come up where there's problems that happen, right? You find a manufacturer or a salesperson that you want to license the ability to sell your product. Well, if they're the only company out there able to sell your product, and they fall short, they've said, you know what, we don't want to sell the product anymore, and they move on to the next one. You want to make sure that contract has teeth that guarantees that if they let it go, you've got the ability to pull the license from them. That's called a performance clause. So it's another aspect of these license deals that are kind of twisted, and you got to build forward thinking about how they're going to function. Another interesting aspect about patent law in terms of licensing is patent exhaustion. When you're selling things like software that aren't quite as tangible, right? When it comes into software licensing, you've got to consider the fact that someone might use your product without your permission after a sale. So patent exhaustion means that you no longer have rights once it's been licensed and purchased. If the person that bought the software can prove that without a doubt there was no conditions on that sale, they can do with that software what they will. So more to come on patent exhaustion later this week. Lots to learn about licenses, but that's a number 2 way to make money in patents. I'm your host, JD Hoovener of The Bold Today Show. Thanks for tuning in. Go big, go bold.